Today, I'll provide a brief overview of what intellectual property is, why we protect it, and how MIT's IP policy applies across the MIT community, from students to faculty to researchers, etc. Before getting into the specifics, it is helpful to start with what do we mean by intellectual property? At a very high level, IP refers to creations of the mind, such as inventions, software, creative works, designs that have value and can be protected under the law. Patents protect new inventions by giving the inventor exclusive rights for a limited time. Copyrights protect original creative works. Think music scores, jazz ensembles, software, books, by controlling how the work is reproduced or shared. Trademarks protect brand elements, names, logos, slogans, symbols that identify a source of goods or services to help prevent consumer confusion. Because IP can take many forms and arise in many different contexts, organizations need clear rules around how it is identified, used, and shared. MIT has its own detailed intellectual property policy that defines and provides a framework of how different types of intellectual property are handled. The policy helps ensure clarity and consistency across MIT, supports responsible innovation, and enables ideas created at MIT to move beyond campus in ways that align with MIT's mission. So as you can see from the slide, this is how MIT defines intellectual property, what we will protect in a broad context. But why? Why do we protect the intellectual property? Intellectual property protection serves many purposes. It helps creators, organizations, and society get the most value from new ideas and discovery. Take a look at this picture. Yes, I know exactly what you're thinking. You don't even have to taste it to know what it tastes like. You know that's a Coca-Cola. It's a very famous trademark, and that is the power of trademark. Trademarks help consumers instantly recognize a product and trust its quality, showing how intellectual property builds brand recognition. For example, the MIT trademark. You see MIT, you automatically think of the best university. You automatically think of science. You automatically think of everything that's come out of MIT. We recently just trademarked Tim the Beaver, and that is another, trademark associated with MIT. Our beaver is recognized as our mascot. IP also protects valuable assets. By clearly defining ownership and rights, IP ensures discoveries are accessible in a controlled way, which encourages investment and enables commercialization, turning ideas into real-world products and services. Finally, protecting IP helps share knowledge publicly with the world. Patent applications, for example, place detailed technical information in the public domain so others can learn from it and responsibly build upon these discoveries. So whether it's creating trusted brands, enabling investment and commercialization, sharing knowledge, IP protection helps foster innovation, economic growth, and societal benefit. While intellectual property protection is essential for encouraging innovation, enabling investment, it is important to recognize that protection comes with limits. These limits, like the fixed term of patents, are deliberate. They create a necessary balance between the creator and the public. IP protection rewards creators and organizations, giving them the ability to commercialize their work. However, limits assure over time knowledge and ideas enter the public domain so society can learn from them, build on them, and continue to innovate. And on the slide, you can see the different limits on copyright protection, trademark protection, patent protection, 20 years from the date of filing. What's interesting about trademark is that you can renew it every 10 years, but you have to show that you've been using it in commerce. You don't want to just trademark things and then not utilize them. That goes against the purpose of having a trademark, being in commerce and being recognized as a brand. So why do we protect the intellectual property specifically at MIT? MIT gets a lot of funding from federal government and industrial companies They do this by providing funds to support research projects on topics of mutual interest to both MIT and themselves. We call this sponsored research. An example of funds coming from the federal government, for example, would be a grant from the NIH, the National Institute of Health. An example from funds, we have a lot of industrial sponsors here, IBM, Microsoft, a lot of funds coming in from the outside that sponsor research at MIT and make research possible at MIT. Think millions of dollars coming into the institute. So when these funds are provided, they're not provided with no strings attached. There's no free lunch. So MIT has to give something in exchange. And commonly what MIT gives in exchange for these millions of dollars of funding is intellectual property rights. When we talk about research pursuant to a sponsored research project, we're talking about anything that's conceived within the scope of work of a sponsored research agreement. And what do they get? What do the sponsors get from MIT? MIT sponsors most often take a non-exclusive research use license to intellectual property that's created under the research they funded. Industrial sponsors, again, may also get options to take an exclusive license to the intellectual property that might be conceived under the course of the research they funded. It's a hotly contested negotiated item, largely because this, to be quite frank, this is MIT. And the sponsors know that the work coming out of their research is going to be foundational and potentially very valuable to their company. And they want to make sure that they have access to it. Again, because these rights are being granted to our sponsors, MIT has to be in a position where it owns, controls, can elect title to the intellectual property. MIT has to be able to transfer to its sponsors, and it has to be able to license. In fact, when we focus on government sponsorship, we have the Bayh-Dole Act, which was an act passed in the 1980s that pretty much drove the tech transfer atmosphere in America. Basically, the federal government gives these grants, as I discussed above, in NIH funding to MIT. MIT conducts the research with this funding. We have to be able to elect title, so we can give non-exclusive rights to the federal government as well. It's a lot more complicated than that, but we have to ensure that we own the intellectual property via our contracts with the federal government and with sponsors outside of the federal government. This is just a quick fact sheet of when, millions of dollars are coming into MIT. Sponsored research helps to drive discovery in our labs. Those discoveries translate into robust and diverse intellectual property ecosystem that we have here at MIT, one that reflects the university's capacity to turn ideas into real-world solutions. So if you look at this intellectual property by the numbers, you'll see that MIT last year had 623 patents filed. We had 282 patents issued, and Trademark alone had $539,000 in licensing revenue. That's from our mark MIT and a variety of other marks. We have almost 4,000 active US patents, and our revenue alone from licensing was almost $61 million. And we make a big impact on the area of startup companies around the world. So we now reflect back on MIT's actual policies to understand how we protect the IP, what type of IP we protect at MIT. Understanding the scope of our intellectual property naturally leads to the framework that enables it. MIT's IP policy is enshrined in MIT Policy 13.1. It details what MIT owns intellectual property of those who have an appointment at MIT, students, staff, faculty, visitors, scientists, etc., and provides guidance as to what types of intellectual property MIT would not assert ownership over. To be clear, MIT does not own everything one might create while having an appointment at MIT. Sometimes some companies' IP policies are very encompassing. I would say MIT is pretty clear on what it will own and what it will not own. And it's detailed in the 4 bullet points on the screen, these 4 scenarios. The first one is quite clear. If you create intellectual property in the course of your employment at MIT, MIT will own it. This is very common, very typical with most employers. As we discussed for number two, as we discussed earlier, MIT has obligations to its sponsors, and in order to meet those obligations, MIT must be able to elect title and or own the intellectual property developed at MIT. Thus, our policy requiring that IP created during the performance of a research agreement, MIT will own that intellectual property. So if you create something while you're working on a sponsored research agreement under the guise of Toyota, say you're working on an autonomous vehicle, and you create something under that, it's going to be owned by MIT. Let's see, research and educational opportunities. If you create something while at MIT that results from a unique educational or research opportunity that's available to you because you're at MIT, MIT will own the intellectual property results from that. And MIT funds, that's pretty straightforward. If you're going to create something using MIT funds, you get funding, you use lab equipment, you use our resources that was funded by MIT. MIT is going to own that as well. But MIT does carve out exceptions. So MIT's IP policy changed in 2023. And as part of that change, MIT carved out exceptions of what it will not own. It will not own copyright in your student thesis. It will not own copyright in creative works, textbooks, scholarly works, publications, musical scores, non-literary creative works such as teaching materials, lecture notes, etc. Open learning and education, except we own the recording of the content. So the IP policy lays out pretty clearly what will be owned and what will not be owned. So a lot of students have a lot of questions of what will be owned in certain circumstances and certain programs that they participate in. So I created this chart to be helpful of when MIT would assert ownership over intellectual property that is developed by students at MIT and when it would not assert ownership. So think curricular courses. So if you're taking a curricular course at MIT as an undergrad or a graduate student, you only reuse resources in that course that are naturally available to you because you're in that course, then you would likely own the intellectual property. But say you're part of the curricular course and then you use resources and funding to build upon at something outside of that curricular course and get resources that weren't available to you despite the aspect of being in that course, MIT could own it. If you're an RA or a TA, you're receiving MIT funds. And at that point, if you create something in that role, MIT would assert ownership, whether you're an undergraduate or a graduate student. MIT often has sponsored hackathons. MIT would not own the intellectual property that results from that hackathon, once again, with the asterisks if you don't build upon pre-existing IP at MIT, etc. Maker spaces. These are spaces around campus that you can use to make prototypes, etc. The mere use of that space will not result in MIT owning the intellectual property. But like I said before, if you use that space to build upon prior developed intellectual property at MIT, or you use other resources outside of that maker space, that MIT could assert ownership. Exempt programs, we'll talk more about this in detail as we go through this presentation, but there are certain programs at MIT where the funding is exempt from triggering MIT's IP policy. These encourage entrepreneurship, and if this is your only source of funding, with the other caveats I explained earlier, you would own the IP that results from that. UROPs, I've been told 80 to 90% of undergrads participate in a UROP at MIT as an undergraduate research opportunity. MIT will own that for the undergrads, any intellectual property that's developed under the UROP. Often because these UROPs take place in the context of sponsored research, you're working in a lab that the research is sponsored, and that all goes back to the beginning that we have to own the IP that is developed with sponsored funding. Now, a lot of people will take internships or externships and non-MIT sponsored hackathons. These are outside the realm. There's probably some contract or agreement you enter into with a third party. Say you have a summer internship with IBM. You're not at MIT during that time period. You're not working on anything at MIT. You likely enter into a contract with, say, IBM, and they'll likely have clauses that they'll own your intellectual property. The big one If you do anything pursuant to a collaboration, sponsored research, or other sponsored agreement, undergrad, graduate, MIT is going to own that intellectual property. Then we come to the exempt programs that I was talking about earlier. MIT supports entrepreneurship. And to help support entrepreneurship on campus, MIT exempts certain categories of funding from falling into the definition of MIT funds under RIP policy. These exemptions are intentional. Delta D, Design X, Sandbox, Sloan Entrepreneurship Program provide entrepreneurship funding and mentorship programs designed to help MIT students explore ideas, test concepts, and perhaps begin building early stage ventures without giving up ownership to MIT just by the virtue of taking that funding. However, it's important to remember, as I said before, that only the funding is exempt from triggering MIT ownership. If these students build upon additional pre-existing IP, they take additional funding, they use other resources, MIT could potentially still have a claim to that IP that is created with this funding. It's also very, I'm going to highlight right here, that you must receive advance approval. So say you get Sandbox funding based on a project idea you presented as part of your application. You must get approval from our office, the executive director, before you proceed in order for that funding to fall into the exempt category. These exempt programs can change from time to time. They're listed on the VPR website of what entrepreneurial programs that provide funding are considered exempt programs at MIT. Then we have the Undergraduate Research Opportunity Program, which I described earlier. It's a great source of funding. A lot of students do Europe's in the fall, spring, summer. It's for undergraduates specifically. They get real-world access to projects at MIT. It's a wonderful learning opportunity. But anything you develop with Europe funding is going to be owned by MIT. That's me. I get a lot of questions about that if they only took $500 from Europe, would MIT still own it? Technically, yes, MIT would own that if you take Europe funding from MIT. And so undergraduates don't sign RIP agreement, which I'll get into more detail later in the presentation. But if you apply for a Europe, before you can even submit your application, you have to sign the IPIA, MIT's IP agreement. It's part of that process. And these are the caveats. I just want to say one more time that you've throughout this presentation. Is this something I want to hit home today? Europe's for credit will still not be student-owned. Certain capstone courses, like the curricular courses, they fall outside of that, such as BeaverWorks. Because they're using government funding, anything that's linked to government funding, MIT will own the intellectual property, will assert ownership over the intellectual property. Then we have maker spaces. Like I said before, mostly MIT students will own the intellectual property if that's the only resource they use at MIT as a maker space. But there are some maker spaces, like I said, that have a link to funding that are funded perhaps by, or they've like a machine in there that's funded by the government. You can always ask the people at the maker space if they have any of those machines or anything like that. I've dealt with some scenarios like that in the past, where we figure out if that use of the maker space resulted in MIT ownership. It's always great to do your due diligence before you start using any space or any resource at MIT if you truly want to not have MIT assert ownership. And the how, this is a significant portion of my job. So we have the Invention Proprietary Information and Agreement, which is the contract between MIT and required IPIA signatories. Anyone who comes to MIT, minus a few exceptions, has to sign the IPIA. We're talking visitors, we're talking graduate students, we're talking anyone from outside the university that has an appointment here. You have to sign the IPIA with a few caveats. For example, federal government employees cannot assign their rights to anyone outside the federal government, so they're waived from the MIT IPIA. But besides this is a strict requirement to get access to MIT. Um, it's important because this is how we assure compliance with Bayh-Dole. It's how we assure that we can elect title and inventions that are created at MIT by people while they're at MIT. Okay, this is the IPIA. This is the standard form. So based on your appointment title at MIT, you might sign a different type of IPIA. If you're a graduate student, an undergraduate student, staff, faculty, you sign this IPIA. Basically, the IPIA is it enshrines when you will sign, as we talked about earlier in the presentation, MIT funds, MIT sponsored research, MIT employment. Once again, it captures under what circumstances you will assign your intellectual property to MIT. It also talks about how we don't want you to bring certain things to MIT that might contaminate our IPIA, our IP. It also talks about how things you learn at MIT are confidential, research proposals, etc., that to not share them outside of the university. Even when you leave MIT, there's ongoing obligations. That's what the IPIA says as well. Say, for example, you leave, you're going to Stanford now, but you were listed on a patent at MIT, you invented something at MIT. We still need you to cooperate in the paperwork, even after you leave. I'm sure that Jonathan can talk more about that, that sometimes people will leave MIT and it's difficult to get the paperwork that we need. But you have an obligation when you sign the IPIA to continue to work through that process. This is the visitor IPIA. So if you are coming, say, from Harvard, MGB, IBM, if you don't have an appointment at MIT, as a scientist, as an employee, but you're just visiting campus, you have to have this IPIA signed. As you can see, it's a lot more lengthy. It's 3 pages. It's a lot of words here. But what's very important about this is how we treat the IP of a visitor depending on where they come from. So if you come from a nonprofit, say you come from MGB and your salary is paid from MGB, we're going to jointly own that intellectual property with MGB. Say you come from a for-profit and say you're just coming from Google and Google's not sponsoring any research that you're coming here under. You're just coming here to Sloan to work with someone at Sloan. Any IP that individual creates from Google, since they come from a for-profit and he's not working on sponsored research that is particularly sponsored for him to work on, MIT is going to own that intellectual property. It's not going to be shared with Google. So this walks through different examples, but also if you come here from Google and Google is sponsoring the research that you're working on, that could be jointly owned and it'll be governed by the terms of the sponsored research agreement. So this one is very particular because it could result in joint inventions, which are a whole other set of complications because now there's two institutions that could potentially own the intellectual property. But that's just if you're a visitor to MIT. I want to highlight the differences versus if you're an employee, faculty, etc. of MIT. And as I said, who signs the IPIA? Everyone. It's a requirement. If you're a visitor to MIT, you cannot even get your appointment approved until you sign the IPIA. Undergraduates, by virtue of being an undergraduate, do not sign the IPIA. But if you do UROP, if you're an RA, if you're a TA, you're going to be required to sign the IPIA in those circumstances. But, your freshman, first year here, you probably haven't seen this form. So that's just a little asterisk for me to talk about as undergraduates. And that's very common across most schools in the United States. The undergraduates aren't required to sign the IPIA. So the crux of the conversation in this presentation is often, I would say, a great majority of my day is spent with people asking, does MIT own what I developed? If I developed something on my own in my garage without using MIT resources, is MIT going to assert ownership? So these are some questions to consider. Was I doing a job at MIT? Was I in the lab? Was I working on sponsored research? Am I receiving funds other than financial aid? Was I collaborating with researchers? So I have a fun example of how I delve into that question. For example, say I had a graduate student come to me who was studying Lyme's disease. Particularly, they are researching ways to treat Lyme's disease. They conduct their research as part of a sponsored research agreement with a local drug company. In their free time, the student develops a system to help detect Lyme's disease quicker. They did not use any MIT resources, any MIT funds, and worked on the detection method with a non-MIT friend from Harvard. Would MIT own this intellectual property? Something to think about. At a very basic level, we start in, well, they did it on their free time. They didn't use any MIT lab space or resources or cells or anything unique to MIT. So the answer would really turn on whether or not the research they did for the detection method was related to their research on ways to treat Lyme's disease. Are those two separate and distinct? Because often a sponsored research agreement will have a scope of work of what MIT is going to have, with the sponsor and MIT are going to have to own the results from that sponsored research agreement. Um, and it could be grand. Anything that's worked on by people who receive this money, who falls in the realm of Lyme's disease, MIT is going to assert ownership. On this particular one, I think the finding came down that they were separate and distinct. Treating Lyme's disease was not closely tied to detection of Lyme's disease as what it said in the sponsored research agreement. I think that was the ultimate finding on this abstract hypothetical question. But these are the type of questions that we get at MIT regularly. If I use MIT, if I, I, how can I not have MIT assert ownership of my intellectual property? Because many people at MIT are entrepreneur. They're here to invent. They're here to create. Often people from MIT come in with their own patents before they even get here. They have plans. It's, really important if you are considering that you don't want MIT to assert ownership over intellectual property to meet with our office, talk about in the beginning what's going on. I can advise you on MIT's IP policy. I can't, our office can't give waivers up front. We can't talk about that, but it's always good to be educated on what MIT would assert ownership over because they're at times can be very close calls. I'll tag team Jonathan in now to see if you have any fun examples of that or any thoughts. I think this is the ultimate question that people have when they talk to our office.
It is. You're 100% right, Carolyn. It is the ultimate question, and really, we're here to we're here to make sure that we get what MIT has the rights to, but otherwise, if we don't have the rights to it, we don't want it, and that really becomes very important when you're looking for funding down the road, when you're looking to spin something up. So when things become valuable, if there's any cloud over title, that's when things start to get expensive. And we really want to hedge that off. When Caroline was talking earlier about the fact that we need to have the IPIA signed and compliance with the IP policy, the reason we need to do that is if we want to file applications at the USPTO, you need a declaration to say, this is what's in my application. I'm the inventor. And those are things where we need to be able to get in touch with you if you have left MIT. We've got confidentiality provisions where you can't take things that you've worked on at MIT and go somewhere else and continue the work there. So there's lots of reasons for it. But as you can see from the presentation, things get very, very complicated very quickly, especially because here in an environment, we have lots of sponsors. We have lots of collaboration. And so it's better to come to us early to try to get some understanding of whether you own it or not. And whether MIT owns it, then wait down the road and have something ugly pop up.
I would say Jonathan's very correct, and it's in everyone's interest to get it correct. Yeah. We want to get it correct. MIT is not trying to grab intellectual property. This is my one takeaway. Everyone wants to get it correct. We want to work with everyone in the MIT community, to meet our goals and mission. We want to get the IP out for the public good. We want to do it the right way.